Blake Bingham. I'm the Deputy State Engineer. So we kind of mentioned this yesterday. In the Division of Water Rights, we have two deputies. One that covers all the tributaries to the Great Salt Lake, and then one who covers all the tributaries to the Colorado River and the severe river drainage. I am the deputy who covers the tributaries to the Great Salt Lake. So those are the three northern regional offices, the one located up in Cache County that covers the Bear River and Box Elder, then the Weber River and West Desert, and then the Utah Lake Jordan River. So I supervise those regional offices. I know customarily the state engineer would come up at the conclusion of the training and kind of present her thoughts. Unfortunately, she's meeting with some water users down in Emery County today, so she sends her greetings and sentiments and appreciates your attendance, as she said yesterday. This is important. I think it's a great value added to us as an organization to have, many water rights disciples, kind of commission, and you can go out and spread the gospel of water rights, right? And you can correct false doctrine wherever you encounter it. So I do want to say, there's nothing I hate more than being wrong. And so I apologize. I did rise to correct some false doctrine, then proceeded to preach false doctrine this morning. So I hope that didn't confuse you too much. As if nothing else, I think it demonstrates that water rights can be complicated, and so the more you know, that it's important to understand that there's always an exception, there's always nuances, and we really do our best to try to understand the mandates through the legislature gives us through writing these codes, these laws that we then follow. So I have a final review slide deck. I'm not sure where the clicker is. There it is. I don't really have a prepared discussion. I'm going to go through these slides and talk about some of the elements in the slides. But really, this is an opportunity for you guys to voice some questions, whatever questions you have. Hopefully, I haven't tainted your opinion of any answers I give by this morning. But I think this is really something that we can dive into. I did take a few notes, maybe some items to circle back to as well, just based on some of the conversations that were being had yesterday and today. But we'll just go ahead and proceed. First of all, what is a water right, and why do we have them? Water right is the right to divert and use the state's waters, right? And why do we have them? Well, it's to promote the order and effective distribution of water and the beneficial use of Utah's water. How and why do water rights vary? Well, how they vary is unlimited. They vary in both types of use, quantities of water, where their use, period of use. Why? Because each use is probably unique, and they depend highly on the nature of the intended beneficial use, and so the component of the respective water right also varies. Oh, and across the United States, I guess that's a broader, I didn't see the small writing. So we all know we live in kind of an arid region of the United States, and we talked a little bit about the distinction between riparian rights, where water is abundant back east, where if you live adjacent to a source of water, you can simply divert that water. In the west, we have more demand than actual wet water, so we live and operate under the system of prior appropriation. This essentially establishes that water rights, you can use water based on the priority, so first in time, first in right, and that way we can ensure that the rights are being placed to beneficial use. That's the ultimate objective. Basic principles, those are the statutory elements. I won't go too much into that. When do you need a water right? Whenever you choose to divert and beneficially use water. There is some provisions for rainwater harvesting, where you simply have to register with the state engineer on the website, but you always need a water right. How do you get a water right? Well, you appropriate one or you purchase one. There are other alternatives, such as acquiring a right through pre-statutory use. We talked about diligence claims and underground water claims. How don't you get a water right? Well, you don't get a water right by simply going and taking water, okay? There used to be, back in the day, I don't want to muddy the waters too much, you have this thing called adverse possession. That's no longer a thing, so if you want a water right, you've got to acquire one through appropriate means. Where do water rights come from? We have the application process. We kind of talked about pre-statutory use. So when I talk about pre-statutory, I'm referring to diligence claims for surface rights or underground water claims for underground diversions and wells. We have decrees. As you understand, the history of Utah has evolved. And, it used to be a part of Mexico, then this kind of quasi-ecclesiastical state of Deseret, and then a territory of Utah, and then finally a state. Well, the manner and ways of appropriating water kind of evolved with it. One of those ways is that there was some controversy over a source, and a judge would issue a decree as to what the individual rights looked like. And of course, we have these federal reservations. Mike talked about those where there's an implied right. If the federal government reserves a portion of property from the public domain, there's an implied right that's tied to the purposes of that respective reservation. So that can be Forest Service ground, national parks, national monuments, those types of things. Priority dates for those types of Federal Reserve rights are tied to the date that reservation was made. Oh, and of course, tribal lands. State water agencies, so it can be kind of got a grab bag of different state water agencies. So if we were looking at ways to, you kind of look at I kind of like to think of it as black hat and white hat. So in the Department of Natural Resources, we have the Division of Water Resources and we have the Division of Water Rights. Water resources kind of the white hat, right? Like they like to give money and like conservation, touchy-feely stuff. And then we're kind of the black hat. We're the regulatory people that no one really want to deal with unless they're on the winning side of an argument. So the State Engineer, Division of Water Rights, we are the regulatory arm for water as far as water rights goes. There are other types of regulatory agencies, the Division of Water Quality and the Division of Drinking Water. As their names imply, they have very narrow regulatory scope. Water quality obviously deals with water quality issues and discharge from treatment facilities and those types of things. And drinking water has treatment requirements for drinking water purposes. But we are in two separate departments. So we got the Division of Water Resources, Division of Water Rights under the Department of Natural Resources. Then you have water quality and drinking water under the Department of Environmental Quality. The question is, everyone based out of this building? No. So this is the Department of Natural Resources building. The Department of Environmental Quality is down the road a little bit further west. It would be nice if they were, though. Maybe not. Too many people in the gym. So State Engineer. State Engineer is kind of a unique office in the state of Utah. It's appointed current state engineer is Teresa Wilhelmsen. You met her yesterday. Appointed for a four-year term, confirmed by the Senate. Licensed professional engineer, requiring practical knowledge of water issues, water laws, and the water resources. The Division of Water Rights, sometimes we'll refer to ourselves as the State Engineer's Office, because that's what it was historically known as. And then back in 1976, it became kind of renamed as the Division of Water Rights. So you might hear State Engineer's Office, Division of Water Rights, just know that those are used interchangeably. The State Engineer serves as our director of this agency. We're under the DNR, the Department of Natural Resources. The State Engineer has very specific statutory mandates with regard to water rights, the general administration. Here's kind of the interesting component, is that when the State Engineer issues an order, there's no, it doesn't go to the Department of Natural Resources for appeal, right? It goes to a judge, goes to the district court. There's no kind of supervising board that says, hey, State Engineer, you erred in this decision. It goes to the courts because we're talking about real property, and so property rights are generally handled at the courts, by district courts. So the State Engineer acts as kind of an administrative judge or an informal adjudicator of those rights. We're a gatekeeper. We like to provide order and certainty to the beneficial use and distribution of Utah's waters. Hopefully, if we're doing our job right, we're reducing conflict, we're resolving issues before they become too involved. and too problematic. We're helping provide clarity so that Utah can plan for the future. And again, decisions are reviewed de novo. So de novo means just it's new again by the district court. So if someone doesn't like an order, they can request reconsideration, and the state engineer can determine whether to grant that or not. But they can also appeal it to the district judge, district court, and the district court can then kind of sits in the position of the state engineer and looks at the application brand new. It doesn't look at the state engineer's decision and say, no, you did this wrong, you did this right. They essentially take on the hat of the state engineer and said, this is how I'm going to rule on this application. Kind of an interesting aspect and unique to the state engineer's role as compared to other agencies in the state of Utah. Informal administrative process is governed by UAPA, so there are a number of rules that kind of dictate how we step through the application process. We talked about filing applications, some of the notice provisions, the opportunity for people to protest those applications, having hearings, and then issuing a decision. Again, they can petition the state engineer for reconsideration if there's something new they want the state engineer to consider. The state engineer does not have to grant reconsideration, but if there is new stuff, then they will often grant reconsideration, then we'll issue another order, either confirming the previous order or modifying it. And if they're still dissatisfied, or if they don't even want to request for reconsideration, they go straight to the district court and request de novo review. We've talked a little bit about the development. Once you have an approved application, now you got to put it to beneficial use, got to develop that, and then file proof on it. Otherwise, file an extension. If you fail to do that, that application will lapse. Once you file proof, you file it with our office, the state engineer will issue a certificate, essentially certifying that you've placed the water to beneficial use. You've seen this map several times. This is a groundwater policy status map. So the state engineer, as part of her administrative duties, establishes regional policies that make sense. As you understand, Utah is a diverse area, has diverse needs, diverse terrain and climates, and so the policies are going to be different depending on the different regions. And sometimes we will enter into cooperative studies with USGS, UGS, some of these other entities or universities to kind of understand the hydrology of an area better so that we can formulate appropriate policy. Talk a little bit about duty, what that entails, maximum reasonable diversion amount. And this is one of the things I wanted to clarify. I think a lot of times we spend a lot of attention on duty values. And just keep in mind, whenever you see a big round number associated with some type of scientific approach, just know that that's an approximation. It's an estimate, right? These duty values were generally based on, hey, about how much water do I need to divert in order to grow alfalfa? So that's why they're at 4, 4.5, 5. They're these big round numbers, right? Because they're kind of approximations. They're not an exact science. When we talk about depletion, that's where we kind of sharpen the pencil a little bit more, get down to the nitty-gritty. And so depletion, sometimes we'll use that interchangeably with consumptive use, kind of means the same thing. It's when water's physically removed from the hydrologic system. So diversion, you can apply water, let's just say for alfalfa. Some of that water is taken up by the root system and transpired or evaporated off the surface. That part is what is depleted, right? The rest actually percolates down or runs off and returns to the system and becomes available for appropriators downstream. So that's why that's an important distinction. And so when we talk about change applications and evaluating the diversion and depletion limitations, it's important to understand those limitations so that we don't impair existing rights by enlarging that wherever it's going to. Jim hit on the water use program recently. We collect water use data in conjunction with the Division of Water Resources and Division of Drinking Water. It helps them to plan and forecast and those types of things and understand what water is being used. It's the water use reporting program is limited statutorily to certain entities, or we can also, or I should say, some entities are mandatory to report to this. Others we may just issue in an order saying you need to report to this water use program as well. How do we collect it? We do it on an annual basis. We have someone who manages that and reaches out to some of these water providers and makes sure that their report is accurate and is what we need. That's it. Let me just pull up my notes, and maybe that will prompt some other questions. I know you guys are hungry, ready to do the test and get out of here. There was some discussion about, when we create a file jacket, when we kind of outline these authorized components of a water right, whether it be the diversion amount, the place of beneficial use, the point of diversion. There was some question, like I think it was raised, hey, if I have an acre-foot volume amount on a well, does that mean I can just take that all at once? And the answer is like, maybe, but the overarching principle is that you are never authorized to impair existing right holders, right? So even though you have this framework of what a right might authorize you to, if by acting within that framework you impair someone else, that is not allowed. Okay, so you might have certain components and certain limitations, but you're never authorized to injure someone else.
Would that be more accurately impair someone junior?
So let me request. He says, would that be more accurately said, impair someone junior? And I would say no, because you cannot technically impair someone who is junior to you, right? Well, you could, yeah. So in a way, right. You can't impact if they acquired a right and were using the water right, and something you did in a change application, even if you have a senior right, and something you did in that change application suddenly changed the amount of water they were entitled to or had access to, that would be an impairment. But it'd be by virtue of that change, which is a junior priority to perhaps the junior. So it's a little bit of a nuanced element, and that's why we say we have a priority of change that kind of helps us understand, well, maybe this is the nexus of water rights that might be impacted by this change based on priority date. But really the overarching principle is you can do no harm by virtue of changing your water right. Now, if you have a senior water right and you're operating however you can within your constraints and it results in less water to a junior user, that's not technically impairment because you're just taking your water that you're authorized to have. So good question, and the answer is it depends, depending on the scenario. That's kind of a cop-out answer, I know, but it does depend. Okay, a lot of discussion, a lot of important clarity with regard to forfeiture and how it relates to conservation. This is something we deal with on a daily basis, and I just want to try to reiterate that when we look at forfeiture, when forfeiture is typically applied, it's associated with the beneficial use of the underlying water right. So meaning if you have 40 acres of irrigation and you become more efficient and you maybe divert less water, but you're still irrigating that 40 acres of irrigation, we wouldn't consider that subject to forfeiture because the beneficial use is the basis, measure, and limit of the right. And so I think that's a common misconception, especially amongst the rural areas, that, hey, if I'm a farmer and I conserve water, I'm going to be penalized at some point. And just recently, this legislative session, there was a law passed that allowed for participants in this agricultural water optimization program to potentially use that saved water in a different capacity as long as it didn't exceed depletion or diversion limitation. So there is some kind of new elements that are attempting to incentivize people to use their water more efficiently, because I think that's always kind of been a disconnect, is what's the advantage to the farmer if I start to conserve, right? I just become, hopefully, maybe it's just easier to have a big pivot than it is to go out and turn head gates. So that's one advantage. But ultimately, we want to make sure that people are using their water to their according to their authorized beneficial use, but also conserving it and using it wisely. And so I think the legislature has caught on and provided some incentives to allow for that. And that's a very new program. We're still trying to figure out how that's going to work. And if you have questions on that, happy to stand by and answer. Go ahead. Yeah, so his question is, hey, so he's painting a scenario, and I'll just repeat the questions to prevent people having to walk a mic out here. The question is, hey, so I'm a farmer, I become more efficient, and I want to use that conserved water. Would the depletion and diversion limitations remain the same? And the answer is yes, because otherwise you might potentially get into expanding the right and that has the potential to impair others. So those depletion and diversion limitations are typically what are going to become the kind of the standard that you can't exceed. And again, it's an evolution, right? Back in the days of the pioneers, they didn't have the means to understand what the depletion of alfalfa was, right? They could make some rough guesses, but they really didn't understand it. So they're like, hey, the best way to make sure that we won't impair anybody is just say your limit is the number of acres of irrigation, whether you irrigate here, there, different types of crop, that's the limit. And so it was kind of their, in my opinion, that was their approach to prevent kind of enlargement and impairment. Now today we have better tools. We're able to kind of understand diversion and depletion more accurately, and so we can use these tools to allow a little bit more flexibility in the application of water. All right, let's see other items. Areas closed to diligence claim. There is a map layer on that Esri interface if you go and look for it. So as the adjudication kind of rolls through and close areas down to diligence claims, hopefully that map layer should be updating it. We were so you can look on that and it'll kind of give you an idea. Hey, is diligence claim allowed in this area? There was a question: how are entities who protest all change applications in the areas viewed or handled? And I would just say we look at each protest and each application independent of the other applications generally. So if the protestant is just likes to protest, that's just fine. We're going to look at their protest as it relates to the respective application and draw whatever conclusions we can without, saying, oh, that's just him or her just protesting, right? We want to make sure that we're giving the adequate due process to all the parties. Yeah, go ahead.
Who pays for the protests to go to court? In other words, can one bad actor, not to name environmentalist groups, but I'll just use them as a scapegoat, can they force the division to have to go to court every single time by just continually protesting and appealing?
Yeah, so the question is, who pays for the protest, specifically when it goes to a court proceeding, right? If there's a bad actor and they just want to be litigious. So that's just a burden that we bear and the applicant would have to bear. So if you have a protestant who is dissatisfied with an order of the state engineer, so they'll protest initially during the application, and let's just say state engineer issues an order and the protestant is dissatisfied with that, didn't go the way they wanted it to go. Yeah, they could take it to court. They would have to bear their burden of the cost. State engineer, we would have to bear our burden of the cost, and the applicant would have to bear their burden of the cost. But that's kind of that's the system of government that we live in, right? That we have property, and that if we want to defend that property, and in some cases maybe the protestant is right, and so you never want to cut off someone's opportunity to seek relief from the justice when it relates to property rights. So yeah, it does. Usually I will say it's not very often because lawyers are expensive and going to court is never fun. But yeah, we do it quite often. Well, they incur the costs associated with the legal fees, right? So there's a cost to filing a protest, $15, right, Eric? So that's pretty minimal, and that was just to say because we had one application that received like 1,000 plus protests, and it was just simply a form letter that was left at a gas station. Everyone, and so he's like, all right, we've got to get some. They needed some skin in the game to file a protest, so we had this little fee. So there's that fee. But yeah, for any type of court action, they're going to have to bear the costs of whatever that entails as far as legal counsel. But that's it, right? You don't want to place a barrier to seek relief from a judge, right? That's a bad thing. But I can understand it's frustrating when certain entities might be more litigious than others, and that results in incurred cost both to the state and maybe to some applicants. Did we cover the governor's proclamation? Just, I'm going to put that out there that the governor, back in November, I believe November 3rd of 2022, the governor issued a proclamation, as he is statutorily allowed to, closing most of the drainage to the Great Salt Lake to new appropriations. Just kind of a heads up there. If you go to that policy page and you select on an area within the Utah Lake Jordan River or the Bear River or the Weber River, it will have a link to the proclamation. There are some exceptions to that currently in place that, it doesn't stop small domestic filings where they are authorized by policy, for instance, or if you have an appropriate mitigation plan that accounts for any depletions. So the question is, does the Great Salt Lake have any water rights? So the Great Salt Lake is not a person and does not own water rights by itself. There are entities in the Great Salt Lake. There are mineral extractors that have water rights in the Great Salt Lake, but there is an agency that has responsibility for the Great Salt Lake, forestry, fire, and state lands. And so the legislature did enact a new piece of legislation that allows people to dedicate their water to the Great Salt Lake under, via change application, or just dedicate it through forestry, fire, and state lands, and then they can use that water in and around Great Salt Lake to bolster it. But no, it by itself does not have its own water rights.
This is just a curiosity, but the recent article that the LDS Church donated the water rights to someone, or they just donated a
Some insight on that? You bet. So recently, the LDS Church, Church of Jesus Christ of Latter-day Saints, donated some shares in an irrigation company to forestry, fire, and state lands for the benefit of the Great Salt Lake. I think it was 5,000 shares in North Point Consolidated Irrigation Company. That is water that is historically been diverted out of the Jordan River from the surplus canal. And so they've donated those. Forestry, fire, and state lands will now need to file a change application in order to have that water dedicated to the lake. So both. So the question is, were they currently using it? They had non-use applications filed on those shares, and so they were protected from non-use. I'll leave it at that. You can draw your own conclusions. It was for irrigation. Generally, the place of use for that company is kind of adjacent to the lower Jordan River, kind of like where the new prison's at in those areas. A question, why aren't all ponds considered recharge? I think one thing to add on what Nathan already kind of talked about that is that, ponds, if they're engineered appropriately or correctly, are specifically designed to avoid being recharge basins, right? Because you want to retain that water. And that water is already accounted for, hopefully, under some storage component of the underlying water right. And so recharge has a different purpose. So that doesn't mean that recharge doesn't naturally happen by virtue of holding water in a pond. But I think it's geared, the type of application is geared towards the intent of the storage of that water, or using that type of facility. Those are the notes I had. Are there any other questions I'm happy to answer? Yes, sir.
so this one deals with public water suppliers. Sort of how does priority cuts,
Great question. So the question is, how do priority cuts relate to a public water supplier? My answer is the same way they apply to anyone else. They have a priority date. They're subject to that priority date. So if they have very junior water rights, which in one instance down in Cedar City, that's the case, where they have a groundwater management plan. They have there's a municipal entity that has very junior water rights, and so they're looking at being curtailed amongst the first cut, right? And so we don't look at them any different. The statute doesn't provide any distinction with regard to priority distribution based on the type of water user, and so they get cut like everyone else, and that happens every year. Municipal entities have water rights on some of these streams based on the hydraulic hydrologic conditions, these streams may provide enough water, but they have cuts like anyone else. For the most part, a lot of municipalities have developed over where there was historical irrigation practices happening, and they've acquired those early senior rights. So in a lot of cases, municipalities have pretty senior rights. But then there are some public water suppliers who have appropriated very junior rights, but they're winter rights, they're storage rights, like Weber Basin Water Conservancy District, right? They have pretty junior rights, but they're being stored during the non-irrigation season, so there isn't much competition during that season, and so their cuts really, there aren't a whole lot of cuts associated with their diversions. I mean, that's just one part of their portfolio. They have other rights as well shares. So, any other questions? Yes, sir. Okay. Yeah, so the question is, hey, can you walk us through a change application scenario where maybe you have an acre of irrigated land and you want to change it to a domestic use and maybe some stock water? What does a depletion analysis look like that? So I'm going to use kind of even numbers to make the math easy, right? So let's just say that in this particular area where this change application is filed, the duty is 4 acre-feet per acre. So in this case, 1 acre would get you 4 acre-feet, right? And again, I'm going to use rough analysis and say, generally speaking, irrigation is about 50% consumptive. So about 2 acre-feet of that is consumed by the historical irrigation practices. So when we look at that, we say, all right, we have this, in barring any other type of potential for impairment, let's just say they're going to take it from, we're not going to change the point of diversion. It's going to go from well to stay in the same well, just to make it easy, because there's always other elements that could creep in if we can move surface to underground or surface to surface, those types of things. So just looking at the straight depletion and diversion, so we have this diversion, 4 acre-feet per acre, depletion, 2 acre-feet. We want to change that to a domestic use and maybe some stock watering. Domestic use is generally, the duty is 0.45 acre-foot per domestic use, per single domestic use. Again, and we're not talking about municipalities, because if they're changing to municipal water right, they simply just get the diversion and depletion and it goes to their portfolio. So a domestic use diversion requirement is 0.45 acre-feet. So already the diversion, all right, you got 4 acre-feet of diversion, we're going to 0.45, good to go right there. Also, when we look at when we look at depletion analysis on a domestic, it's generally about 20%. And so we assume that about 20% of an indoor domestic use is consumed. So we say, all right, well, we've got 0.45 acre-feet of the diversion accounted for over here, and we got 0.2 acre-feet, or excuse me, 20% of 0.45, so that's a 0.09 acre-feet, right, of depletion. And so we kind of do this analysis and say, all right, now we've taken out of that 2 acre-feet of depletion, we've accounted for 0.09. And then usually what happens is the applicants say, and they just max the rest out on stock, because that's 100% consumptive. And so each ELU for a year-round period of use is 0.028 acre-feet. And we assume that, stock never relieve themselves anywhere, so it's 100% consumptive. So we just say, all right, 0.028 times how many ever number of stock you get to account for the remainder of that depletion component, and then that kind of becomes, all right. And usually what ends up happening, if you're going from a more consumptive to a less consumptive use, you kind of, it trims down on the irrigation or on the diversion quantity needed for the hereafter. And so that's kind of the analysis, and without like a calculator in front of me and without precise, but does that kind of get at the crux of what you're asking? Yeah, a lot of the time the depletion kind of governs what beneficial uses can be met on the hereafter side of the change application in most cases. Sometimes we'll go from stock water, which is 100% consumptive, to domestic, right? So again, we say we have this block of water, and let's just say it's, I don't know how many stock it would take. Well, we'll just call it 100 stock or 1,000 stock. That would give me 2.8 acre-feet of diversion and depletion. And so now you got that whole chunk of water that you could apply towards whatever purposes on the hereafter. It's just kind of a math game. And if you're ever confused and you want to know, hey, I have this water, what are the prospective beneficial uses that I could have on the other side of this change? Just come in. This is stuff we do every day, and we're happy to help out. And again, those depletion amounts, as far as irrigation go, depend on where you're at and what depletion station we use to calculate that. But we generally use alfalfa, it being the most consumptive crop, and just assume that. There is a movement to kind of fine-tune that a little bit, but right now that's kind of our standing policy. Any other questions? Yes, sir.
Well, I guess I have two. First, is there a place on the website that shows the diversion depletion rate for each water right when you're looking at it? Or the maximum diversion depletion rate?
So the question is there a place on our website to identify the maximum diversion and depletion rate for each water right? Diversion is really easy because it's just right there on the database, right? We have a field that shows what it's authorized to divert under flow rate. So diversion is pretty straightforward. Depletion depends on kind of the era in which the water right was approved or changed. These days, whenever we issue an order, we will generally identify the depletion limitations associated with the beneficial use. But it's not in that database field. There is an internal kind of thing that we can look at, but again, it may take a little bit more digging to identify what the depletion is. But again, if you have a question about any particular water right, just call us up and we'll say, yeah, this is probably what you're looking at for this water right, if it's not spelled out in an order or a certificate or something like that. Did you have a two-part question? All right. Do you want me to expound on that, or? Okay, so his question relates to groundwater management plans, wherein the state engineer goes into a basin, identifies that it's beyond safe field and that we need to get it back into safe field. So we're looking at the hydrologic components of the basin itself. And the question is, if you're going to go in and we're going to start curtailing junior rights, who pays for that taking? And I say no one does. Well, the applicant, the person who, there's no taking, because just as a river provides an amount of water, and if a junior right holder doesn't, if they kind of go down the list and satisfy senior rights, and then they run out of water before they get to the junior rights, that's just the nature of the system of prior appropriation. The reason why priority hasn't worked well with groundwater and why we have to do groundwater management plans is because it's not very clear. It's not like a river where you say, yep, we're going to carve off this, and okay, junior priorities in this year, you're out of water. We have this aquifer, which is kind of massive, and the properties are not well known sometimes, and the ability to withdraw water in one place, it's not really clear how it affects others. And so that's why we kind of got to look at those in a more regional view in these groundwater management plans, and then introduce the concept of priority distribution on a groundwater aquifer basis. So it's really the same principle as surface water distribution by priority. It's just that we haven't done it everywhere because they take a lot of study to understand what the aquifer characteristics are, how much water is available, what a safe yield is, and then we've got to go, and we have a very specific statutory framework in which we have to operate in order to implement a groundwater management plan. But to answer your question is, it's not considered a taking. It's just considered distributing water by priority. And senior water in Utah, we operate under the law of doctrine of prior appropriation. So senior water rights get satisfied before junior water rights. And then it's very easy for me to say that, right? It's much more difficult for someone who has a junior water right in these basins to suddenly say, I'm no longer going to turn on my faucet or something to that effect. So that's why when we implement these, we usually give them quite a long time, like 80 years to get to a point. And they're kind of tiered cuts. And so it's never fun. And we always try to collaborate with the users in the basin to make sure that we mitigate some of those harmful effects of cutting people off who maybe don't have any other recourse to get water for a house or something like that. But it's kind of where we're at, unfortunately. Any other questions? Well, great. You guys have been a great audience. Are there any questions online at all?
There is. Thanks. We have a question. Let me pull up the chat. Jeff wonders, does the calculator provide prospective beneficial use estimates?
Does the calculator provide prospective beneficial use estimates? You know, I'm not sure exactly what, I mean, so when you put in the calculator, it will show what amount of water is required for that respective beneficial use. So to that extent, yes, it does. I'm not sure, but maybe I'm missing the question, but yeah, so essentially you put in, hey, I want to do this, this, and this, and it will spit out on the other end, hey, you need this much water, and you need to have this much depletion available. So if you're considering a change application, and you know I've got this much acreage of irrigation, and I can figure out what the depletion element and the diversion element of that, and then I want to do this, it'll kind of help you figure out, all right, this might be a reasonable amount of water to satisfy my uses on the hereafter of the change. It doesn't guarantee anything, right? It's just kind of an estimate, because there are these other issues, whether it might be impairment and these other type of considerations we've got to look at when the application's before us. Any other online questions?
That's it so far.
And hopefully we've buried that water use calculator sufficiently so no one ever relies on it. No, I'm just kidding. I have hard times finding it as well, but it can be a valuable tool if you know, I think we kind of live and operate in this space, so we're very accustomed to what those quantities would be, and we can, except for like how much water does it take for a chicken and those types of things, I do have to go back to the water use calculator to see what we've said there. But any other questions?